Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal at Carter Arnett in Dallas. Robert has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Leanne Lyon, and today we are looking at how real estate and construction conflicts come up and what it takes to resolve them efficiently. Bob, what kind of real estate or construction disputes do you often see making their way into Texas courts?
Money disputes. I mean, generally on construction cases, somebody's not getting paid. They maybe file a lawsuit, maybe file a mechanics lien, and then there's invariably a construction defect counterclaim that's filed. Sometimes it's the project has gone through to completion, and it's the owner that's initiating the litigation, claiming that they're construction defects. So those are probably the most common in terms of the construction world. In terms of real estate, real estate is a pretty varied area. There's lots of different kinds of disputes that come up. Probably the most common are, contract disputes, real estate purchase and sale agreements. One side doesn't perform, or one side, backs out of the deal during the due diligence process, and there's issues about whether they're entitled to do that, or somebody else comes in with a better deal, and the seller reneges on the deal that they've got to go with the better deal. And then you've got, not only a breach of contract case, but also a tortious interference with contract case. So those are probably the most common that I see.
Well, it sounds like a good variety of common. But when a disagreement starts on a construction project, what usually determines whether it can be resolved informally or when it's going to turn into a more full-scale litigation?
Depends on the nature of the issue, obviously, but
right.
I think the good faith and the reasonableness of the parties to try and negotiate past a problem, or to arrive at some resolution is important. There's also in many construction contracts, many real estate contracts, there are provisions for providing notice to the other side that there's a default or some non-compliance. There's an opportunity to cure period, and so following through on that, parties can sometimes get past the dispute or come to some sort of resolution where they can avoid going to court.
Well, let's talk about construction cases. How do courts typically handle questions about delays, cost overruns, or alleged defects?
So I guess let me start with the defects. That's a fact-intensive question. Like I said, almost all construction cases deal with either the owner bringing a case alleging that there are construction defects, or a contractor or subcontractor bringing a non-payment case and facing a counterclaim that there are construction defects. Mm-hmm. And it depends on the nature of the defect. You're going to have to have recourse to the construction drawings and the specifications to determine whether it was whatever the particular system or component was built in accordance with the drawings and the specifications. You may need, depending on the nature of it, you may need expert testimony from an architect or an engineer, either a civil engineer or a structural engineer. If it's on workmanship issues, you may need, for example, if there's issues about concrete, you very well may need an expert in concrete to testify. So I would say, that's how those are chiefly dealt with in bigger cases. and we've got some really huge construction defect cases in Texas involving hospitals, high school football stadiums, et cetera. That is really, it comes down to a battle of the experts in terms of whether something is built in compliance or whether there's actually a defect that exists or not, and if so, what needs to be done to fix it. So that's I would say that pretty well covers how those things get resolved. In terms of if you're an owner and you're making a claim against an engineer or an architect, at the outset, you need to have what's called a certificate of merit that goes along with your petition, your initiating document, where somebody with the same license and practicing in the same area uh, signs an affidavit saying that they've reviewed the drawings, they've reviewed the materials available, and they conclude that there was a failure to comply with the relevant standard of care. So that's sort of one safeguard, and then there's ancillary litigation about whether the certificates of merit comply with the statutes, and if they don't, then they get tossed, and the case can be dismissed based on that.
Many people assume that construction, real estate law would be kind of cut and dried, but boundary or title issues can actually get emotional and expensive. How are those cases usually proven, and what kind of evidence matters the most?
Well, what matters the most is the the title records. I mean, the records, the deed records. You may have to trace the deed back over, you know, many decades. The chain of title
Mhm.
for boundaries. I mean, generally speaking, you don't have fights between surveyors very often because they are going off of known landmarks and using lasers and uh, surveying equipment that you know either it's right or it's not right. But sometimes there are issues where you may have an older deed and the description that's attached to a deed or oftentimes attached to a deed is called a meets and bounds description, and it's uh, a whole series of compass headings and distances in feet, and they trace it around, and it's the outline of the property. And you know, back in the 30s, 40s, 50s, surveyors didn't have as sophisticated equipment that they do now, and sometimes you wind up with odd little situations where the lines don't come back together. In other words, there's a gap there where the boundaries don't meet, or the one surveyor will do it, and it'll be inconsistent with another one. Um, so that takes you back to the as far as you can go back to the granting deed, the original grant, to figure out what the correct one is, and then I guess other issues come up in terms of emotional ones. If somebody dies and there's no provision in the will for where the property goes, and it goes to their heirs, and a lot of times the heirs can't agree on what to be done with the property, and you may wind up with a partition action where the court decides either here's how we're going to divide the property and give different pieces to the different heirs, or we're just going to have to sell the property and then divide the proceeds up among the heirs. Some of those get emotional and testy, when you have family members who are fighting with each other.
For sure. Well, for commercial landlords and tenants, what tends to be the most common source of litigation in lease disputes?
Again, money. Almost always, it's non-payment of rent. Um, and occasionally there can be disputes when you've got either a build to suit kind of situation. In other words, the landlord really just owns the piece of property,
Mhm.
and they're uh, a contractor's engaged to build a a building to suit the tenant, and sometimes there can be ancillary disputes about that, about because the landlord is going to have approval rights and so forth, but the tenant is the one that's paying. And this most commonly comes up with fast food restaurants or Starbucks. You see, standalone buildings. Those are most usually are just ground leases. In other words, the landlord owns the land and then enters into a long-term lease, and the tenant then builds the building. But at the end of the lease, obviously the landlord winds up owning the building as well. Um, but there can be, disputes about the design and the quality of the construction, and particularly if the landlord may own other property surrounding it or in the vicinity, about egress and ingress and impact on other tenants.
Oh, good points. Well, how important then are contracts like AIA agreements or purchase and sale documents in shaping the outcome of these cases?
Well, they're critical.
Mhm.
Um, Now, I will say, for selling real estate or conveying an interest in real property, including leases of over a year,
Mhm.
it has to be in writing, or it's unenforceable under the statute of fraud. So purchase and sale agreements are usually detailed. For commercial properties, they can run on to 100 pages, and so they set out the terms and conditions, the requirements for closing, et cetera, with a great deal of detail. And not to say that there can't be fights about the proper interpretation of it, because that does occur.
Mhm.
Um, Construction contracts, the AIA is the American Institute of Architects, and they've done a good job, I think, of developing form contracts that are pretty even-handed, although favorable to architects. Um, but as between owners and contractors, they are, I think, pretty fair, pretty even-handed. The However, it's not required to have a construction contract. Um, in the I tried a case last October where it was a contractor and a landowner. The landowner was also acting as the general contractor, and the contract was basically a one-page proposal that had been sent by email and was countersigned. Well, you can imagine that there wasn't a whole lot of detail there, and it left a lot of room for interpretation and argument about what the deal actually was. So, yeah, what's in the contract um, matters a great deal. And courts will usually enforce contracts as they're written, and jurors will enforce contracts as they're written. Jurors think that contracts are very important, and they expect people to live up to the contracts that they sign.
Real estate projects often involve multiple players, as you mentioned, like architects or owners, contractors, lenders, insurers. How do you approach allocating responsibility when several parties are pointing fingers?
Well, that's up to the jury. When you get down to it, I mean, you can attempt to negotiate things, particularly on larger projects. Say the owner has complaints about defective work or deficiencies in a building system. Well, then it comes down to, or it can be, is it a design problem? In which case, it's the fault of the architect or the engineer, or is it a construction problem? In which case, it's the fault of the general contractor or the subcontractor, or is it both? And if it is both, then you're going to wind up in an apportionment question. So that's going to be for the jury to sort out, and again, guided by expert testimony on both sides. The other complicating factor is, say the owner sues the general contractor. Well, then the general contractor may wind up bringing in as third-party defendants a bunch of different subcontractors that were all had some hand in the system or the component that's at issue. In which case, you've got a whole bunch of differing views on what happened and why, and potentially what needs to be done to correct it.
Well, you've mentioned expert witnesses such as appraisers, engineers, surveyors. Obviously, these play a huge role in helping judges or juries understand these disputes. Is there anything more you can explain to us about those expert witnesses?
Well, it depends on the case. Obviously, if it's a if it's a case where an owner has claimed that the architect screwed up the design, then there's going to be competing architects, and you know they're going to have primarily recourse to what the code requirements are, et cetera. Um, if it's and now the architects are also responsible for writing the specifications. So if the specifications perhaps don't comply with code or don't spell out closely enough what it is that the contractor is supposed to do, then you may be also bringing in, for example, manufacturers representatives who you know promulgate information on how to apply their products or how to use the components that they make. If it's an engineer, then again, you're going to have a fight between engineers about whether there is a defect or not. Um, if it's so you've got civil engineers and you've got mechanical engineers, and and then you've got structural engineers. So the civil engineers really deal with um, things like grading, foundation, drainage, uh, MEP or mechanical. MEP stands for mechanical, electrical, and plumbing, and so they deal with um, HVAC systems. They design the electrical systems. They design the fire sprinkler systems. They design plumbing to include wastewater, as well as you know if it's a big facility, you may have a different variety of water systems that are being utilized. Mm-hmm. So there can be all sorts of issues that arise in those areas. Um, appraisers, if appraisers come in typically when the 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 theory of damage is, I should have had a building worth $100 million, and now because of these defects, my building is only worth $75 million, and so you're going to have appraisers that fight over that, or come up with their own opinions about that. Surveyors generally, I don't find many disputes among surveyors. It's really a question of that comes into boundary lines. Did they build, if there's a setback, or did they build within the setback? And if they did, why did they not have it staked out properly? Or surveyors are also important in elevations, determining elevations. They've got to go out and check the elevations to make sure that the excavation and grading work before the foundation gets poured is proper and is at the right height and everything's compacted well. You also have geotechnical experts if you've got settlement problems, because projects, there should be a geotechnical assessment that's done before you even start the work, so that you have expert information about how to prepare the ground for whatever building that you're going to be putting on it. So it can get complex. Yeah.
Well, finally, what steps can property owners, developers, or businesses take early in a project to minimize the risk of finding themselves in court later?
Well, I think number one, make sure that you spend the time and the money to make sure that your contract is as accurate as it can be. Um, some contractors aren't very good about that. They delegate that role to somebody who maybe doesn't fully appreciate all the implications, or all what the consequences could be of not getting something right. So take the time to thoroughly review and negotiate and draft your contract so that they reflect the deal that you think that you've got. That's number one. And in Texas, there's still a lot of folks who a man's handshake is his bond, and they go off of oral contracts. And I understand that ethic, but that's not the best way of proceeding if there's going to be a dispute later on. And then once there starts to be problems, is to try and get in front of them and bring the other side in for a candid discussion about what the situation is, and how's the best way to address it. Part of the problem, well, not part of the problem, but many contracts are fixed sum contracts. In other words, I'm going to build your school building for $25 million. All right. Well, if there's some unforeseen subterranean condition that's now going to make the excavation work and the foundation work, much more expensive, a lot of contracts will have a provision that there can be additional costs based on that. So if the contractor determines that that's the case, rather than just proceeding and assuming that they're going to be able to get paid, you need to get out in front of that and get the owner involved and figure out, okay, how much is the extra cost, and actually follow the change order process that's in your contract. Because most construction contracts require that if there's going to be a change, either in the time to complete the construction or the cost of the construction, that you have that in a written change order that's signed by the owner prior to the time that you do that extra work. And typically, the architect is involved in deciding those things as well. So get out in front of it and be candid, rather than okay, well, here's a problem, but we can patch it over like this way and maybe they won't find out, is not a good idea.
That is great advice. And that is also it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Robert and his firm's work in business and real estate litigation, visit carterarnett.com. And thanks for listening. Remember to like, subscribe, and leave a review if you found this episode helpful. Thank you, Bob.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.